Welcome to this free immigration help channel. Today I'm doing another one of these videos where I'm going through all your comments and answering your immigration related questions. This is volume 20, and yes, I know I've just done a volume 19, but today is Saturday, so I decided to catch up because I do get a lot of questions. Now before I start, again, I'm going to mention, just like I mention in every single video I make, I am not an immigration attorney. This is not a legal advice. All the information that I provide in my videos are directly from official sources like USCIS.gov, travelstate.gov. These are all the official government websites. Okay, so without further ado, let's start with the very first comment from Simone Williams. Thank you, very informative information. You're very welcome, Simone. Thank you for watching. All right, next question from Agwenjung. I'm sorry if I'm not pronouncing your names correctly. Wow, thanks so much. I filed for my spouse in September 29th, 2022. Where will my case be? And how may it take for my husband to come over, please? Okay, so September 29th, 2022, it depends on what status you are in. Are you a US citizen or are you a legal permanent resident? Now, most of the times whenever you're filing for spouses, there isn't really a lot of difference. Those cases are processed pretty quickly because whenever it comes to the immigrant visas, there is no cap on immediate relatives like spouses and children who are unmarried and who are under 21. But I'm going to show you. It's a good opportunity to demonstrate the navigation on USCIS website. So since you filed just now, recently, September 2022, that is what? October, November, December, January. So about 4 or 5 months ago. So that means your case is most likely still with USCIS. It has not been transferred to the Department of State yet. So I'm going to show you how to pull up those dates. And we're going to go to Tools, right here at the very top of the navigation menu. Then we're going to click on Case Status Online. And I'm sure there's another way of getting it, probably faster to processing times. But this is how I used to it. I like to stick to what I'm used to. But we're going to select the form, which is I-130, Petition for Alien Relative. And the category is going to be, now it depends on you. If you're a legal permanent resident, you will be selecting this right here, the first one, permanent resident filing for a spouse. If you're a US citizen, you will be selecting this one. I'm going to show you both times for both. And I don't know which service center you filed to because it depends on from which state you're filing. But they are, most of them are pretty much the same with the exception of a few months. So for example, California, if you're a permanent resident, it's going to be 25 months. So just a little bit over 2 years, which it sounds like a lot, but usually they are processed a little bit faster because it's, like I said, first priority. And then if you're a US citizen, it's half of that time. Now, if you change between the, let's say, California and Texas, it's going to be a little bit of different time as well. So depending on where you filed from and depending on your own status, these are the timelines. Somewhere between 1 year and 2 years. But like I said, because there is no cap on the amount of immigrant visas that are issued, most of the times it is processed much faster. So I'm gonna put the saying that I answered. I'm gonna copy it from here. And if you have any additional questions, don't hesitate to post it in this video. Okay, moving further. Olive Basco, F1 visa, Jamaica, hot topics. Okay, so I'm assuming you're referring to F1 category immigrant visa, not the F1 student visa. But yes, it is a very hot topic, not just in Jamaica, it's really everywhere. Just because it's kind of a controversial, that cap. And if you haven't seen the video that I've recently made, it's actually this video right here, Understanding Visa Bulletin. Make sure to check it out, because if you will ever be dealing with family immigration, or you are, planning to eventually deal with family immigration, or you are right now dealing with family immigration, check this video out. It will be definitely helpful. Okay, moving further to Jainab. I was on asylum pending. Okay, I got divorced with my ex-husband. I have 2 kids. I'm married again. Now 4 months. can apply for a green card or should I wait? Okay, Jaina, interesting question. A little bit of situation you got there. So I would say it's going to depend on your marriage. I'm assuming you married a green card holder, legal permanent resident, or U.S. citizen. That's the only way that you can be petitioned for by your petitioner, sponsored by your spouse, right? If they are legal permanent resident or if they are U.S. citizen. Okay, so that's number one thing you need to figure out. Number two thing that you need to figure out is your asylum case that is pending. If you are petitioning, well, if it's not going to be you petitioning for yourself, it's going to be the petitioner, your spouse, who will be petitioning for you. If there is another case that is being started, then you need to take care of the previous case and make sure that you withdraw it so that it's not two cases going there, because that can create confusion. And I actually seen a really bad situation where both of the cases were happening at the same time, and obviously you pay attention more to your new case that was recently submitted because it is for a green card. It's obviously much better than the asylum, and it was actually practically exactly the same situation. That case, because the person did not pay attention to, they missed the interview or something. They missed an important date, and it was actually denied because of that. And the person went into the deportation proceedings because of it, because it was denied, while they had this actual separate application going, separate petition. So make sure something like that doesn't happen. Another thing that I wanted to point out in your thing, and that would be the last thing, whenever it comes to 4 months, whenever it comes to the timeline when you can apply for green card if you married legal permanent resident or U.S. citizen. It doesn't really make a difference whether it's 4 months or 4 days. As soon as you get married, you can immediately, if let's say I'm a U.S. citizen and I marry a woman that is not a U.S. citizen, not a legal permanent resident, I can tomorrow petition for her to get her status adjusted. But with that being said, again, it's not you applying for that status. It is the petitioner. You're the beneficiary. So it is them that have to do that first step and submit that application. So a few things for you to keep in mind. Hopefully it was helpful. If you have any follow-up questions, go ahead, by all means. You can post them here in this video and I'll try to get back as soon as I can. All right, moving further to YT A3X Mega. I don't get a welcome letter after getting approval notice of I-130. What can I do? Okay, excellent question. So whenever it comes to the approval notices, I'm sorry, not the approval notices, welcome letters from the NVC after the approval notice from USCIS, right? So the way it works, I'm going to describe it briefly for those who are not familiar with the process. Whenever you're petitioning, for the alien relative, you're submitting everything, the application, the petition to USCIS. Once USCIS reviews it and approves it, right, if they approve it, they transfer your case to the NVC, to the Department of State, for further processing. Once it is transferred, you usually get the welcome letter from NVC saying, hey, you need to log into the portal, you need to fill out additional information, you need to provide these documents, that. That's kind of briefly described the process. So there are a few reasons why you might not get that welcome letter from NVC after you got approved by USCIS. Most likely it means that you do not have that visa availability, that immigrant visa, just yet. Not you personally, but your beneficiary. So depending on which category your beneficiary is in, and I actually do have Visa Bulletin website open here in front of me. And again, I've done this video just a few days ago. Check it out. It's going to be very helpful. Understanding Visa Bulletin, why is there an immigrant visa backlog? In that video, I describe, we talk about the separate categories that are available, why there is a backlog, what the difference between the two graphs are, and the dates. So for example, For example, let's say you file your petition for your, let's say you are a U.S. citizen, and you filed a petition for your brother who lives in another country, right? That would be a category F3, I believe. F3 or F4. No, it's actually F4. F4, brothers and sisters. So your brother and sister in the fourth category, basically. That's what it means. Let's say USCIS reviewed it, maybe a year or year and a half, they reviewed it and they approved it. Now the case is transferred to the Department of State. And now you never got the welcome letter, you don't know what's going on. So the F4 category looks like right now they are processing applications filed back in March 2007, which is the final action dates. The dates for filing are a little bit closer in December 2007, but pretty much the same. And I described the difference between the two, what these two graphs mean. You can refer to any of them. There's just going to be a little bit of difference whenever it comes to the dates. So those people who filed for their brothers and sisters, those U.S. citizens that filed for their brothers and sisters back in March 2007, just now their cases are being processed. So with going back to your question, whenever it comes to the welcome center, welcome letter from NVC, you get that welcome letter usually about 3-4 months when the date of the processing, when that visa becomes available, closer to when that visa becomes available. So I hope I was able to answer your question. I know it was a long answer, but it is a little bit of complicated. Depends on a lot of things, but I hope I was able to make it clear. Okay, let's move on to the next one from Lay Visa. Hello, I'm filing I-130 for my wife. I am retired and living in Cambodia. We have been married 17 years and have 2 children, ages 15 and 13. They are U.S. citizens. Okay, so I'm assuming your kids are U.S. citizens, but your wife is not, since you are filing for her. My application I-130 was denied by USCIS, and somehow the email was deleted accidentally while I was reading it and could not go back. Gotta get it back. Okay, what should I do? Thank you so much. Okay, Lay, a few things that I want to ask. First of all, it sounds a little bit weird with the email. Your case was denied. First of all, why your case was denied? That's one thing I really want to know, because it sounds like you have a solid case. You are filing out there. So you don't specify whether you are U.S. citizens or legal permanent resident, but it doesn't really matter because you can file regardless for unless you are not a legal permanent resident and you're not a U.S. citizen, then yeah, you cannot petition for your wife because you don't have either LPR status or U.S. citizen status. But I'm assuming you are, and based on that, your case shouldn't have been denied. But I really want to know why your case was denied. And also, whenever it comes to emails, usually USCIS, they send by mail the notice of action, especially the second notice of action, because it's an important one. Yes, they email you stuff too, but they always mail whenever it comes to the notices of action, whether it's a receipt or whether it is the approval or denial or whatever decision kind of they make. They mail it. So you should have had that paper form. So we definitely going to need some more information to answer your questions regarding what should you do. Again, most of the times it's going to be in the notice whether you can appeal, or if it was denied for some kind of mistake, whether you can reopen the case, resubmit the application. It's all there. So there is a comment, check the trash folder. Yes, definitely do that. Check your email. Maybe you can pull up that email. I mean, it's very, very important email. But also you should have had the mail if you have the correct address specified in the application. But I am looking forward to more information from you. Hopefully I was able to help. Obviously you can reach out to, USCIS. That would be the only ones. There's no point to reach out to the Department of State because your case has not reached the Department of State yet. So you can definitely call the customer service, USCIS. Not going to get much information. Much better to actually find that missing email and see where that mail went to. Okay, moving further, we got a question from Trisha G. What about humanitarian reinstatement? How long will this process take? Okay, Trisha G, actually excellent question. Thank you for bringing that up. I have not had a question like this yet. Basically, humanitarian reinstatement is it's a very specific, very not very popular. Okay, and the reason for that is because it's very it happens. It's there in place whenever a petitioner files the I-130, right? If that I-130 has been approved by USCIS, but that application was not completed yet with the NVC and the petitioner passed away, the petitioner died, in that case, the beneficiary can file for humanitarian reinstatement. That's what the humanitarian reinstatement is for. So, Trisha G, I'm gonna give you a big answer so that whoever's watching, they also can know the process. If you are filing the humanitarian reinstatement, the only way you can file the humanitarian reinstatement is if the application was already approved for USCIS. So that's one of the requirements. Number 2 requirement is that you will have to find a new sponsor, okay? Because the sponsorship, most of the times, USCIS does not make exceptions whenever it comes to the sponsorship. So obviously, because the main petitioner passed away, now you will have to get a different sponsor who will agree, who is 18 years of older, who is a legal permanent resident or U.S. citizen, and who is willing to basically be a sponsor on that petition. And another thing that I wanted to mention now, specifically to your question, Trisha, whenever it comes to the humanitarian reinstatement, it's left up to USCIS basically to decide whether they want to grant that humanitarian reinstatement or not. And they don't wait in usually, for example, if you qualify, if you meet all the requirements, that's it, you get it, right? This is not the case with the humanitarian reinstatement. With the humanitarian reinstatement, even if you qualify, even if you find the sponsor and you submit all the documents to USCIS for that humanitarian reinstatement, they can say no if they decide that, well, you know, it's been too long or something or whatever. So unfortunately, it's not, nothing is guaranteed in immigration whenever it comes to the immigration process, but more so the humanitarian reinstatement. And usually they take absolutely forever because of the fact that humanitarian reinstatement, just those applications are not a priority for USCIS. And usually it's about, I would say, at least 2 years before that request to do the humanitarian reinstatement is even considered. So if there is a way to avoid that, I would highly recommend doing that because it's just seems to be in most of the cases just unnecessary, you know, gathering documents and filing and waiting. Okay, moving on to Ida Trinidad. What about LPR wife? Why this is taking so long? Okay, so LPR wife. It's thanks for asking, Ida. Actually, great question. I'm gonna show you two separate processing times, important processing times whenever it comes to I-130 application. So we're gonna check first processing times for the LPR wife. We already have I-130. So permanent resident filing for a spouse, that would be it. Depending on whichever, I'm gonna select taxes, but most of them are pretty much the same. About 2 years, right? 20 months, about 2 years. That's 80% of the cases. Meaning that there are quite a lot of cases, 20%, that's a lot of cases, can take longer, few months is longer, and few months is faster. But that is just on USCIS side. Now, because whenever it comes to the NVC side, the Department of State, because there is no cap on the immediate relatives of legal permanent residents and U.S. citizens, those applications, once it is approved, once USCIS has approved your application, your I-130, they transfer it to the Department of State, and then usually within 2-3 months you get a welcome letter from the Department of State, and then you start the whole brand new process of, filling out the application, submitting the financial documents, and all that sort of stuff. So with all of that, you're probably looking roughly, if this is how long it's going to take on USCIS side, additional 3 months there to get the welcome letter, then to complete all of the documents about a month, then for them to review it about 3 months, another 6 months roughly, so 2 years plus another 6 months. And then you have your interview with the medical examination, that's another month. So I would say about 2.5 years, between 2 and 2.5 years for the whole process. So hopefully I was helpful with that, and now hopefully after me showing you this, you can pull it up yourself if you need to follow up on the information. But on the plus side, you don't have to deal with the visa bulletin at all, which is a huge plus, because now you're in the F2A category, and the F2A category is always current because there is no cap on those applications, unlike a lot others. Okay, let's move on to the next one from Tasha Uni Harrison. Hello, I'm in the F2B all chargeability area, and my priority date is October 2015. How far away do you think I am from March 2021? Okay, documentation qualified from March 2021. Okay, so Tashani, unfortunately, you will be waiting for some more time because the priority date is October 2015, which means that right now, as of 2023, they are reviewing stuff that was filed back in October 2015, which is a delay of 8 years, about 8 years. Which, if you estimate, it's very rough estimation because things can speed up, things can slow down. But rough estimation is if there is an 8-year delay, and right now it's 2023, that visa, that immigrant visa for your beneficiary will become available in 8 years, which means right now it's 2023 plus 8 years, around 2031. That is if things stay exactly the same. Hopefully things speed up, but if things stay exactly the same with the same backlog, again, I highly recommend checking out the video that I made on Visa Bulletin. It's this one right here, Understanding Visa Bulletin, why is there an immigrant visa backlog. There I explained that, the priority dates and all that sort of stuff. But on the plus side, you have already got everything from NVC, and you have already qualified, documentation qualified, which is great. It takes time, and I saw quite a lot of denials and additional sponsors, and you have to fill out this, and you didn't provide that, and then some more information is requested. You're already done. So the only thing that you need is patience. I hope you have that, and I hope I was able to answer your question. And let me know if you have any additional questions. I will be happy to answer them. All right, let's move on to the next one. I'm gonna try to cover a couple more. Let's see. Maybe I can stick to this and not to make this video too long. All right, from Rosa E and Angelina, we got a question. I am American citizen, and I am petitioning for green card for my Brazilian husband and requesting for my daughter to become American citizen and her passport. I have been living in Brazil for more than 10 years. I have not done my income tax. Ooh, okay. Do I have to do my income tax to have their paperwork be approved? Will I lose my citizenship? I only did the I-130 and I-130A. Is there more forms to fill out? Okay, Rosa or Angelina, whichever one. Great question, and you definitely do have a little bit of the case, a little bit of a delicate case, should I say. Let me start by this. Will I lose my citizenship? No. Typically, that doesn't happen. Just because you live somewhere else, typically you don't lose American citizenship. Like green card, yeah, that status is easier to lose. Citizenship, you're probably not going to lose it. It takes some serious effort to lose that. Not in your case. However, you do have to maintain that tax information going. That's definitely important, and that's one of the things that will absolutely be required for you to actually provide to NVC, to the Department of State, showing that you do have the income, because you are sponsoring. You are the petitioner, so you are one of the sponsors for your husband and your daughter. So I would definitely recommend reaching out, if you can, to a tax professional. Obviously, here in the United States, the CPA. I've done a video where I explain the tax filing for immigrants. So check it out. Might be helpful. You can do it all yourself if you find enough time to sit down, do your research, and actually file the tax returns. The little bit of a complication might be with showing the income, because in your case you will have to show the income from a foreign country, saying that, hey, I have enough money to sponsor my husband and my daughter. I don't know right out of the bat what are the minimal requirements for the income, but you can definitely find it. It's readily available. But just in case, I would recommend in your case trying to find another sponsor, just in case. Just in case, be prepared if NVC, once your case is transferred to NVC, requests the your financial information. If it's not enough, you will have that sponsor that you can add as a joint sponsor on the application. Now, getting to your very last question about the forms I-130 and I-130A. No, there isn't any forms to fill out right now as of this moment. This is what is necessary to start the petition for alien relative. And looks like you already done it. The only thing I want to ask is, have you received the very first notice of action from USCIS saying that, hey, we received your application and basically we accept your application? If you got that, great. The only thing that you need to do is just have some patience and wait until your case is approved by USCIS and then transferred to the NVC. But I do expect some follow-up responses and some additional information, and I hope that your case goes well. You can always ask additional questions here on this channel and I'll be happy to get back to them. All right, let's move on to the next one from Diesel. Question regarding NA that is not applicable. In boxes left empty. Does that mean specifically in part 7 after I check box A stating J can read and understand English? There are box B and number 2 left empty. They don't apply like you showed us. Do I write not applicable on those? Also, for the part asking for any family members, that does not apply to me. So do I fill out not applicable on numbers 7 to 11? Or can I just leave them blank? And since no family member on part 8, that whole page does not apply to me. Do I fill every single thing with not applicable? My last question is, after I completed this, I am still very confused on the N400. Is that another form I have to mandatory fill out in order to send this? I'm only trying to get my green card renewal fee waived. Okay, Diesel. So let me start from the very last question that you asked. No, you don't have to worry about the N400. N400 is an application for naturalization. I think in this video, file for free. Anybody who's watching this video, by the way, if you want to waive the fee, there is a way to do that. So if you're interested in doing that, check out the video that I've done. File for free. That's how it starts. But I think I used in that video N400, which is the application for naturalization, as an example. You don't have to worry about that. So you are only filing your application for your, whether you're adjusting status, your very first green card, or you're renewing a green card, whatever it is. Whatever application that you're filing, you're attaching the fee waiver, the Form I-912 with it. For USCIS to consider to waive your fee or not to waive your fee. Now, going back, I'm really glad you asked this question, because a lot of people don't seem to pay attention to what I'm saying about the blank boxes. So I'm really glad that you paid attention. Thank you. Here's the thing whenever it comes to the blank spaces, right? Like I said, I've seen a lot of applications come back. Most of the times, USCIS, they complain about the blank spaces when the blank spaces are for your personal information. So let's say, for example, you go and there is let's say there's a place where you need to put in the passport number, and then there's an option for the travel document, right? Blank space. Let's say you have the passport number, you filled it in, but you don't have a travel document. But you could have a travel document, and USCIS does not know if you had the travel document or not, obviously. That's where you want to put that not applicable. For sure, 100%, you want to put that NA in that blank space if you don't have the travel document, all right? But with the situations like with the application that you were asking, right, where you already said that yes, I can understand and I can read English, and you already signed, then technically you already answered this. So there is no way for someone to say, wait, no, I don't understand English, and then type it in something else. In that case, it shouldn't matter. However, with that being said, I still recommend, just to be on the safe side, to put not applicable in there. It is silly, I agree, but it prevents unnecessary delays in your application, because you can imagine how much time it will take for USCIS to review your case, and then because of one field they say, oh, we're gonna send it back, and tell them to put not applicable in that blank field, and then they send it back, you get it, then you open it up, you fill it out, you send it back, and then it's ridiculous. So instead of doing that, just put not applicable, just to be on the safe side. But let's move on to your second question here. Or does this form have to go with form I-90? Okay, so I-90 is that green card renewal that you're doing. So yes, it will go with the I-90. Sorry, I did too much talking today already. So I'm gonna put that here, and we're gonna try to address the very last question here for today, and then I'll let you go because we are already past the 30-minute mark. Okay, so the last question for today is from Samwati Gafur. How many years does it take for a visa for a citizen sponsor of unmarried children? How many years does it take for a visa for a citizen sponsor of unmarried children? Okay, great question. It depends if your unmarried children are under 21 or over 21. Believe it or not, it's absolutely ridiculous. And again, I'm going to point you to that video that I keep pointing everyone in this video. Check it out, Visa Bulletin. You will learn quite a lot. I wish I knew that back whenever I was filing, and I still have someone that I'm waiting for, one of my relatives, but it really clears things up. So if your kids under 21, then they fall in that immediate category, immediate relative, where there is no cap on immigrant visas. So once the USCIS approves the case, that's it. It's immediately transferred to NVC, to the Department of State. It's immediately processed there. And when I say immediately, it doesn't mean like right now. It means like 3-4 months, which is typical delays with these things. But it's considering that how long this takes, it's really, really fast, 3-4 months. But if they are over 21, now we get into the Visa Bulletin, which is the category F1, which is unmarried sons and daughters of U.S. citizens. It doesn't say here over 21, but that's what they are. It's over 21. And it's F1 category. And as you can see right now, which is absolutely ridiculous, don't ask me why, ask the Congress why. From December 2014, which means that if you file today, they're processing stuff from December 2014, which is 9 years delay, which means if you file it today, rough estimation is going to be that application is going to be not reviewed, the visa is going to be available in 9 years unless things speed up. So hopefully I was able to answer your question, and hopefully your question is about a child who is under the age of 21. So I really hope Congress does something about it. And I'm going to read the comment from Michael Hathaway. It depends on the country you're applying from. Yes, it definitely does. Again, check out that Visa Bulletin because there are chargeability areas, and if this is for F1 for all chargeability, if you're from Mexico, for example, it's much longer. It's April 2001 that they're just now processing, which is even more ridiculous. But yes, it's fast for Ukraine and the other United countries. I sponsored someone from Russia and it took 3 years. Okay, Michael, I really, really appreciate your comment here. And with that being said, I wanted to say and encourage everyone who's watching these videos. First of all, thank you for watching. Thank you for your support, your super thanks, and your memberships. You're supporting this channel. I really, really appreciate it. But I will also want to encourage everyone to, if you are watching these videos and if you see the comment and if you know the answer or you've been in a similar situation, you went through a process, please comment, please answer. That would be really, really helpful. As always, thank you for your time. I hope I was able to answer your questions. God bless, and I'll see you in the next video.